Hello and welcome to the Womxn Show. I'm Lenina Rasool, and today we are speaking about children in conflict with the law. Now, young people committing crime is a huge problem in South Africa, especially because of our high rates of gangsterism and drug use, and often the burden of this falls on parents. Today, we are speaking to a representative of Legal Aid South Africa, their Cape Town office, to explain to us what to do when a child gets arrested. But before that, let's have a look at a short video speaking about youth in conflict with the law.
We are children and young people passionate about child rights and the law. Many of us have been affected by the justice system, such as being detained or going to court, because at some point in our lives we faced discrimination and inequality, or difficulties such as domestic violence, abuse, and exclusion from education.
And my first time that I had an experience with the juvenile justice system was at the age of 12. Black and Latino people are less likely to graduate college, but more likely to be arrested in schools.
The 2019 UN Global Study on Children Deprived of Liberty found that over 7 million children were detained worldwide. We feel that justice systems do not make children's rights a priority, leaving many feeling harmed, ignored, and traumatized. Focus on punishment and blame instead of rehabilitation and peace. The Global Initiative on Justice with Children was created the year of the 30th anniversary of the Convention on the Rights of the Child. It includes an online platform for practitioners and world congresses on justice with children. The 2021 Congress brought together 9,000 participants from 6 continents.
Torture and cruel, inhuman and degrading treatment of children persists at a large scale. Extrajudicial killings, either of street children or children from vulnerable backgrounds, and extensive pre-trial detention, sometimes for years, including for petty crimes.
Legalize violence against children as a sentence for a crime, such as capital punishment, life imprisonment, and corporal punishment, continue to exist. These types of punishment are clear violations of the rights of the child. The deprivation of liberty of children should only be used as a measure of last resort and for the shortest appropriate period of time possible. Children should not be imprisoned.
We work together with leaders and experts to create the Global Declaration on Justice with Children. We are asking governments and civil society to work in partnership with all children to make sure their rights are fulfilled. We want equal access to justice that does not discriminate for any reason, to share our opinions and have our views taken seriously, to make decisions about our own lives and get support from adults when we need it.
I fight not about people that are not listening to me, people that was listening to me, but they wasn't making any actions. Support adult children to have access to them child food and to have decision, and support them decision and them voices.
We also want our mental health and well-being to be looked after.
A lot of children who are deprived of liberty have some form of neurodisability and mental health issues, alongside chronic trauma issues from childhood, which makes it more likely you will be in a freeze, fight or flight mode. So you need to be looked after with a trauma-informed kind of way.
We want young people under 25 to have the same protection as children and to understand our rights so we can trust the police and courts.
As a queer child, you experience much more discrimination and you're often dismissed or even put at greater risk by police forces. There's a large lack of trust in the institution.
We want help and information to manage crises like the pandemic.
During times of pandemics and other emergencies, key bodies within child protective and justice systems must be prioritized to assure that every child receives the services they need and deserve.
And to learn about and take part in restorative justice so we can repair relationships in our communities.
Restorative justice allows the offender and the victim to forgive each other and, in case of the victim, to better understand why the offender acted in a certain way.
Our goals are justice with children today and tomorrow, justice for children without discrimination, justice for children during crises, child-friendly access to justice for all children.
We should all crave for a world where there is no discrimination, no child labor, no child marriage, no child soldiers.
Children must be included, not only as participants, but also as speakers and experts.
That's how we can be sure that adults are listening to us, because they start to share the power that they have with the other generations that are coming.
Become a part of the puzzle. Join the movement now.
That was a short video on youth in conflict with the law. We are going to take a short break, but we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and today we are speaking about children in conflict with the law. And joining me is Thanaa Abrahams. Hi, from Legal Aid South Africa, the Cape Town office. Thanaa, thank you for joining us.
Thank you for inviting me.
So Thanaa, you work primarily with children and children's cases.
Yes.
And so I think to start with, can you tell us what you do? And also, what kind of work that you do in terms of children in conflict with the law?
Okay, so I'm stationed at a child justice court in Cape Town Magistrates Court. And my duties are that once a child gets arrested and is brought to court, I then legally represent the child. That is, if the child and the parents opt for legal aid. So they do have a choice. They can appoint a private attorney. However, I would say 98% of the matters that come to our court, a legal aid represents them. So I would represent the child, and my job is basically to ensure that the best interest of the child is always the primary factor in any proceeding. So whether it's bail proceedings, whether it's the preliminary inquiry, whether the matter goes to trial, I have to make sure that the child's rights are upheld, child's rights are protected, and that we finalize the child's matter without any unnecessary delays, and that the utmost ethical standards and professionalism is maintained within the courtroom when we do deal with children.
Okay, great. Thank you so much. I want to ask you, so when we're talking about children, are there specific age groups or differentiators when to classify sort of a youth and a child?
Yes. So the law basically classifies children in terms of 3 categories. Okay, so you have your 0 to 12-year-olds, then you have a 12 to 14-year-olds, and you have 14 to 18-year-olds. And these are the children that are basically dealt with in terms of the Child Justice Act. So the Child Justice Act dictates that a child under 12 years old who is alleged to have committed an offense can never be arrested.
Okay, wow.
So that child should never be arrested. And there is an irrebuttable presumption that this child does not have criminal capacity. So what is criminal capacity? Criminal capacity is basically where, if we say a child has no criminal capacity, it means that the child is not able to appreciate the difference between right and wrong and act in accordance with that appreciation. So, this law is irrebuttable, cannot be overturned. It's a general rule. Children under 12 do not have criminal capacity, so they can never be arrested and never be prosecuted. But we do find that these children do come into conflict with the law. And when that happens, the police can take the child to the police station, but the child needs to be handed over to a guardian as soon as possible.
Okay.
So a parent or guardian needs to be contacted and the child must be then handed over. If a child who is detained in a police station does not have parents or guardians, it becomes a bit problematic, because then a probation officer needs to be sourced, and it would be someone within the court's jurisdiction or the police officer's jurisdiction, and an assessment needs to be done of the child. And if there's no guardian, no parent, I mean, there's a child that lives on the street, has been neglected, abused, parents died, there's nobody to take care of the child, this child should then be referred to the children's court, and children's court should then find a place of safety for this child, a child and youth care center.
And does that then sort of also bring Department of Social Development?
Yes,
and social workers?
yes. So they are, I think, the most important role players in a child's life under 12 who's coming into conflict with the law. Sometimes there are parents or guardian, but an assessment still needs to be done, because, you know, we feel that if a child comes into conflict with the law, there's always an underlying reason. So it's possibly abuse, neglect, exploitation, drug abuse. So an assessment needs to be done by the probation officer. And this probation officer would then delve into the social circumstances of this child. And the probation officer would have to come up with a written plan of how we are going to assist this child. So they provide support services. And this is all the Department of Social Development. They provide support services. They can refer the child to rehab if there's a drug abuse problem, counseling and therapy if the child was physically, emotionally, sexually abused. They can refer the child to programming by accredited organizations. And these programs need to address the child's specific needs. And, or, you know, sometimes you can write it off as youthful indiscretion and take no action at all. Okay? So
but ultimately, we shouldn't have kids 12 and under incarcerated.
No, not at all, not at all. And, you know, this written plan that the probation officer comes up with, it actually sets out the responsibilities of the parents as well.
Yes.
To make sure that going forward, child does not reoffend. So that's the first category of children. Okay, they're not arrested, they're not prosecuted, but there are times they are referred to DSD for assistance and support services. Then you have children aged between 12 and 14. Now here there is a rebuttable presumption that they do not have criminal capacity. So they too are presumed not to appreciate the difference between right and wrong at the time of the offense, and so that they cannot act in appreciation, in accordance with that appreciation, sorry.
Thanaa, before we go forward, I want to ask you about sort of the rebuttable assumption, criminal capacity.
Yes.
My understanding it's got something to do with like intent. Is that sort of what we mean, or what do we mean when we say they're not capable of understanding the difference?
I think it has more to do with fault than intent, and basically understanding the difference between a right and a wrong. And, you know, some kids would, I'll just make an example. You have a kid, he walks into a shop and he's thirsty. And he needs something to drink, so he takes a bottle of Coke or a bottle of water, and he felt that he was basically justified by doing that because he was thirsty, he needed to drink some water. So they don't basically fathom the consequences of their actions, and they don't know that they're actually breaking the law and they're doing something wrong. They feel justified because I'm thirsty at this point in time and I need something to drink. So they don't fully understand it doesn't belong to you, you need to pay for it. So that's basically, I think it has more to do with fault than intention. And like I say, the law imposed these age limits because generally, if you look at our children, generally, when they do fall in these categories, they're not mature enough. They're not mature enough to basically understand the difference between right and wrong and actually act in accordance with that appreciation. So it is rebuttable because, we can't take an armchair approach. Every child is different. Every child has different levels of education, maturity, exposed to different factors. And that is why children between 12 and 14 are presumed not to have criminal capacity, okay? So if the state feels that a 12-year-old or a 13-year-old does have criminal capacity, okay, they then need to prove beyond a reasonable doubt that this child actually does have criminal capacity. And the way they do that is the child needs to be referred for a criminal capacity assessment, okay? So here's where experts come in, clinical psychologists, psychiatrists, and they will assess the child and they would make then an expert determination of whether the child does have criminal capacity. So what they will look at is the child's age, level of maturity, cognitive abilities. Can the child count till 1,000? Look at certain skills that children can do. They'll look at growth and development. They will look at socioeconomic and environmental factors. They will look at all those things to make a determination as to whether this child does have criminal capacity or not. I am yet to see a child under the age of 14 that has criminal capacity because we've referred a few children and the report almost always comes back and indicates that this child does not have criminal capacity.
Oh, wow. Okay. That's interesting.
Yeah. And then the last category and the most common category is your age between 14 and 18. So they are still minors. And there is a rebuttable presumption that they do have criminal capacity so that they know what they're doing is wrong and they can act in accordance with that knowledge. If a party alleges that the child does not have criminal capacity, that party has to prove it. So example, me in court, I have a 15-year-old and I'm busy consulting with this child and I feel like this child doesn't understand me and he doesn't grasp like basic concepts. And I delve deeper and I speak to mom and mom says, this child has fetal alcohol syndrome. He was born with fetal alcohol syndrome. He had a learning difficulty. He dropped out of school, standard 1 or grade 3 because he cannot cope with the schoolwork. Then my, light bulbs will go on. This child could possibly not have criminal capacity. And then the state can either withdraw the matter or if the state is insistent on going through the system, I would then have to provide the expert. So I would have to, as the defense attorney, refer the child for a criminal capacity assessment and get that expert report.
Okay, wow. And so when we think about children or minors who are incarcerated, we are usually looking at the ages between 14 and 18.
Yes.
And we have sort of juvenile spaces. I don't want to use the term sort of prisons, but places where they are incarcerated for minors specifically.
Yes, so they are child and youth care centers.
Okay.
And we call it level 3 facilities because it's a restrictive environment. So, the child's freedom is curtailed. However, these child and youth care centers are really doing a great job because all the child's basic needs are being met. So they have clothing. They wear uniforms so nobody feels out of place. So they have clean clothing, warm beds, warm water. They eat very well because I notice the children that goes to a CYCC and comes back a month later to court, you can see how much weight they've put on. And they tell me they eat well at these places. I mean, they even get pudding. So, there are child and youth care centers and children should not be detained in prisons. There are exceptional circumstances where children are actually sent to a prison. And that is when the child offender is over the age of 16 and has, it's alleged that he committed a Schedule 3 offense, which is your more serious cases, your murders, your rapes, and there is no place available at a child and youth care center.
Okay.
So it's a measure of last resort.
Yes.
Yeah. So, we always, always, always try to secure a place for a child at a youth care center to make sure they still get schooling, they're still allowed to play soccer, they're still allowed to be children.
So Thanaa, I want to bring it back quickly to, and we're going to look at like what the process is supposed to be once a child gets arrested. But you mentioned something earlier. You said the best interests of the interests of the child and the child's rights are upheld and protected. And I just want to speak to that and speak to the fact that there are these youth care centers where the children are fed, well looked after, they're provided with everything they need. And I think also programs, right? Rehabilitation programs and other things. I want to give an example. So I worked with an NGO once a long time ago, and we visited a child and youth care center. I think it was Boys Town.
Bonnie Town,
yes. And it was, you know, one of the things that came out in the discussions with the young boys was that, you know, they go into the centers and they learn a lot of things. So they love the programs that they're going through. But what happens also is that once they are done, you're saying once they come out, once you see them a month later, they go back to the same environment where they were. And because there's nothing at home, they fall back into those sort of pathways to crime. And is this something that you see?
It is very common, but that's why, you know, if for example, if a child comes to the Child Justice Court and the child has, for example, a drug abuse problem. Okay. And this child, you know, he doesn't sleep at home. He lives an emancipated lifestyle. Mother can't control him. Then, in those circumstances, if the mother comes to court and says, I can't with this child, he doesn't listen, then the court will make a determination that it is in the best interest of this child to be detained and to get rehabilitation. So, what happens is we postpone the matter to get a detailed assessment report, and this report is compiled by a probation officer and sets out basically all the factors that the court needs to consider to make a diversion order. So it will take into account the child's background, the child's schooling, where the child lives, what drugs the child is on, how often the child smokes, etc. Then the court will make, for example, an order that the child go to rehabilitation programs and programs at the Child and Youth Care Center, like a restrictive environment. So they go into these programs, and the programs are not necessarily a month. Sometimes we do it according to the child's needs. So sometimes these programs can run up until a year. So the child stays at the Child and Youth Care Center, but it doesn't stop there. So after the program, child will be 16 years old. And, you know, we can't take chances. So what the court will do is you attend the program, the court will make two orders. You attend the program until the program finalizes and you turn 16. And once you are released from the program, I am going to place you under home-based supervision for another year.
Yes.
So basically, in the Child Justice Court, there are means and ways for aftercare services. So the court will make an order. Okay, so once you're released, you are going to live back at home. You are not going to leave your home between 7 in the evening and 7 the next morning unless accompanied by parent or guardian. I'm making an order that you do not use any drugs, any alcohol, that you do not have negative friends or bad friends. I'm making an order that you do not come to Cape Town CBD jurisdiction without your parents or guardians. And those are all measures to basically to try and prevent this child from reoffending. And then there would be a probation officer that's going to monitor this. Okay, so then you'll have a probation officer or an assistant probation officer that knocks on the child's door to check. Are you at home after 7, like the court said? And they can do random drug testing. They can phone and say, where is this child? Is this child at home? Is he behaving? Etc. So there is still that monitoring that can take place even afterwards. So
what's interesting about this is that, you know, and we have to go to break now soon, but it's just, what's interesting is when you think about it in terms of the best interest of the child in the way you're describing, and it's not actually punitive. It might come across as punitive, like punishment, but it's not supposed to be
at all. The purpose is basically to rehabilitate this child and so that once he becomes an adult, he can become a valuable contributor to society, and that he doesn't reoffend. So it's more about restorative justice. It's more about preventing stigma to the child. We, like I said, the best interest of the child is of paramount importance, regardless of the crime or the alleged offence. We focus on the child.
Yes, and so that child can grow into, as you're saying, a whole contributing member of society. And also, it's interesting because what the court seeks to do really is fill some of the holes that were there prior to the child sort of committing the crime. Holes that might have led to the child
There was a
committing the crime.
reason the child committed the offence. Sometimes it's a cry for help. I have kids that come to court and say,
sorry, Thanaa, we have to go to break quickly. We are going to take a quick break, but we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and we are speaking about children in conflict with the law. And joining me is Thanaa Abrahams from Legal Aid South Africa, the Cape Town office. And Thanaa, before the break, we were talking about sort of more around pathways to crime that children, how children might end up there, looking at, how the court addresses this not from a sort of punitive or punishment perspective, but rather as diversions to help them, heal from whatever caused them to go there or to get into crime. But I just want to speak about now in our second segment, what do parents do if their child has been arrested?
Okay, so I'm going to talk from a practical.
Yes, please.
I'm going to take a practical approach. Okay, so once a child gets arrested, like I say, under 12 won't be arrested.
Yes.
But once a child about
Can I stop and then just ask? Okay, so a child under 12 has committed a crime. Let's say it's shoplifting. You used that analogy earlier. Let's say it's a big store, right? So not the corner shop. I know what usually happens is they get taken into the office, whoever it is, by the security. And usually what I've heard is that the managers or whatever will call the police. So the police show up.
Yeah.
This kid is 11 years old.
Okay. Yeah.
What happens there?
So what happens is the police must try and ascertain where the parents of this child is. So if the child can provide a phone number, parents can come to that office at Pick and Pay or ShopRite and come and collect the child. The police are allowed to take the child to the police station, but not under lockup and detention.
Okay.
And that is just basically to get more information from this child. Where can we get your parents? Some kids do not know their addresses. Mm-hmm. Some kids do not know parents' phone numbers. Some parents do not have phones. So what the police can even do is escort that child to go and point out where they live.
Okay.
So the child would say, I live in Woodstock. I don't know the name of the road, but I can take you there. Mm. And then the child must be handed over to the parent or guardian. And like I said, it becomes problematic when there is no parent or guardian. Because we do have children living on the streets without any parents. They're orphaned and they have no visible means of support. And that's where DSD comes in. Mm. So the probation officer will then come in, do the assessment, and if the child is a child in need of care and protection, and that's stipulated in Section 150 of the Children's Act. If they do fall within that category, then the probation officer needs to ensure that the child is placed at a child and youth care centre.
Yes, and that's roughly if they don't have anyone to take care of them, it's just care or protection is if they're in danger of being abused at home or anywhere.
Yes. So basically, children under 12 must be handed over to the parents.
Okay.
That's it. Okay? And then we have children above the age of 12 that are arrested, and if it's for a Schedule 1 or Schedule 2 offence, so we're talking about your shoplifting, possession of drugs, And this is now excluding the Schedule 3 matters, which are rape, murder, etc. Because for those matters, they cannot be released at the police station. So you're talking about your common robbery, your housebreaking when nobody was at home, theft out of a motor vehicle, those types of offences. Child is arrested and detained at the police station. So the police need to inform the parents immediately.
Yes. Can I ask, so when they're detained at the police station, do they then go into sort of, can I call it lockup? I don't know.
Yes. They are, but they are kept separately from adults. So it's totally separate from adults. And then the parents would arrive at the police station. Parents need to bring proof of age with. Okay, so you need to show that this is indeed a child. So proof of age can be in the form of a birth certificate, a school report, a clinic card, etc. And it would be advisable that parents bring along proof of address. Okay, but if they don't have proof of address, it's not the end of the world. The parent is there. So the child can be released in the parent's care or the guardian's care at the police station if it's a schedule.
That decision?
The police. So the police and or the after-hours bail prosecutor. So, we have after-hours prosecutors on duty for after-hour bail. So they will make that decision. And that is obviously if there is no alarming issues. The parent can say, no, he lives with me, he's a good child, I don't know why I did this, come, I'm taking this child home. And that's fine. Then the parent and the child will get a written notice to appear at court on a future date. Okay? If the child is not released at the police station, so we cannot find parents, child is not cooperating, parents' phone numbers are off, etc., the child needs to be brought to court as soon as possible. So preferably by the next day, before the expiry of 48 hours. And at every court, there is a probation officer stationed. Okay, so the probation officer will try to elicit information from the child, and myself, the prosecutor, all the role players will try to locate the parents of this child, if there is parents, and also to determine the age of the child. So child will say, the last school I attended was whatever school, we then phone the school. Do you have a contact number for parents? Do you have a birth certificate on record, etc.? And if the child has not been released at the police station, they can be released at court. Okay? So the probation officer's recommendation would be based on her evaluation and whether the child is a child in need of care and protection or whether the child is at risk. She will basically, and 90% of the time, we release the children into the care of the guardian. So the court will make that decision. You are now released, but the important part is that parents need to be present. They need to participate. They need to come to court. They need to pitch up. They need to give information regarding the child's schooling, his behavioral patterns, whether there's drug abuse, whether they are bad friends. They need to give information.
Can I ask you a question? So let's say we're talking about someone, they're under 14. They are, and we've seen this. We see often it's mothers. Before something has happened, will approach social workers. They're struggling with their kids. The kids on drugs, or the kids, drinking. So they get to court. The child's been arrested and released before. The mother's there, but she's like, Judge, I don't know what to do anymore. He has a home. Can the magistrate still, make a diversion order? Still sort of bring in DSD? Can they, in terms of best interest of the child, can they still sort of assist in those ways?
Yes. So we find that too. We have parents that have approached DSD long before the child even committed an offense, trying to get help. But once the child has committed an offense or alleged to have been committed, to an offense to have been committed, the process becomes easier and we can actually expedite. So mother has been trying to get child into a rehab. Mother has been trying to get this child into a restrictive environment because child lives an emancipated lifestyle. He ran away from home. He stays on the street for 3 months at a time, comes back to visit for a day, runs back to the street. And we're talking about 12-year-olds, 13-year-olds. So there is problems. And in that scenario, if mother comes to court and say, you know, I've tried everything, I cannot control this child, the court will make an order that the child be detained, so he's not released. So the child will make an order that this child is at risk of harm to himself and to the community, or he falls within the Children's Act. He is a child in need of care and protection because uncontrollable behavior is
a risk
listed. Yeah, it's listed and that could deem you a child in need of care and protection if you display uncontrollable behavior. Children who are abusing drugs, addicted to substances, that is listed, that can deem you a child in need of care and protection. So the court will then make an order that the child not be released, that the child be detained at a youth care center until finalization of the matter. So like I say, after that we're just talking about a release here and bail proceedings. So there's still a whole process after that, so they will remain at the youth care center until the matter's finalized, until we get a report stating what that child really needs and what we can do to address those needs. And then the matter will be diverted. And then most likely the diversion order will be a level 2 order where the child remains at the youth care center, completes programming, completes rehab, gets intensive counseling and therapy, because they have that at youth care centers. And the child will basically remain there. And it becomes very formal when you have a child that's arrested for a Schedule 3 case, Schedule 3 offense. So
which is like murder, rape, and
your violent crimes and your very, very serious crimes, okay? And you have a mother that says, you know, my child is a good child. I can't believe this actually happened. I want my child to be released. But in that case, a probation officer assesses the child, and a probation officer always has to assess a child, okay? And this is what we call the preliminary assessment. So probation officer assesses the child, and you know there's some risk factors. This child is not at school, or this child smokes dacha every day and he feels it's not a problem. So there are some risk factors. But mom says, you know what, I want my child to be released. I can't control the child. And the state says, or the prosecutor says, you know, we are opposed to his release. We feel this child is at risk. And then me as the defense attorney has to apply for bail formally. Okay, so then it takes a whole formal procedure. And basically the court will ascertain from the parents whether they are able to control this child and what measures the family is going to put in place to make sure that this child does not reoffend.
Can I ask, so if the child is awaiting a bail hearing, again, I'm just talking about, you know, they are incarcerated for a little while until that hearing, not at the police station, where are
the
there
child
also
in youth care center.
Okay.
Yeah, we will place them at a child in youth care center pending their release. Okay, so parents would then have to convince the court, I can't take care of my child, I can't control him. These are the measures I have now put in place to ensure that once he is released, he will not reoffend. So that takes the form of oral testimony. So parents are going to have to come and testify in court and show the court and convince the court that it is in the best interest of the child to be released.
And is there usually monitoring attached to that also? Then the child is released on bail. There have been promises and orders made in terms of what the child can or can't do while they are. And let's just say a bail, if you're out on bail, you're still awaiting a hearing. So there will still be another hearing.
Yes. So basically what happens is, if there are risk factors, but you know, there's many principles that courts have to consider when it comes to the release of the child. And those principles are things like, you know, a child cannot be treated less favorably than an adult. So if an adult would have been released for this type of offense, the child should be released. You know, detention and incarceration should be a measure of last resort for children. And if you're weighing up the two, incarceration versus release of the child, the law says that preference should be given to the release of the child.
Yes.
Okay? So the court will consider all these things and make a decision. So if the court finds that it is in the best interest of this child to be released, and you know, school-going child is always a good factor. The fact that the child is maybe not on drugs is a good factor. The court will still impose conditions of release. So your normal conditions. I'm releasing you, but throughout this matter, until the matter is finalized, you will reside at home. You will not sleep out. You will be at home from 7 in the evening till 7 the next morning. You cannot leave your home unless accompanied by appropriate adult or guardian or parent. So you can't go with your friends to Canal Walk. You know, I'm making an order that no drugs, no alcohol, and no negative friends should enter your life. So you can't, and there'll be random drug testing. Like I say, there will be this monitoring. The court can even say, I would want you to report periodically to a specific place or a specific person. So the investigating officer, he would want to see you every week to make sure that you are still okay. The court can even make a compulsory school attendance order. If there's evidence that the child has been truant or they're bunking a lot or those types of things, the court can make an order that you need to attend school every day. And if there's evidence that the child is not complying with the court order, then the child can be brought back to court and we can revisit his position. So then there's a chance that he might be sent to a child and youth care center because he's not complying with his conditions of release.
Okay, wow. So there's a lot of options, it seems, and again, you know, just to say, hearing this contextualized within the best interest of the child is really different to the narrative that we usually sort of hear about. I think just also, if the child is held, you know, with regard to the bail hearing, you mentioned the child must come before the court as soon as possible, within 48 hours at least, but as soon as possible actually, and then they could be granted bail for the next hearing. Is there, just in terms of time, and so that people can expect, my perception from what I read is that these processes often take really long. Is that?
Okay, so I won't say these processes take long. So like I say, a child comes, he's in custody. So child comes from the police station to our cells at court, which is separate from the adult, and the child is incarcerated there at court. There's a probation officer. Probation officer assesses the child, tries to get information to see what is in the best interest of this child. Is it for him to be released or is it for him to be detained?
And then also what is wrong? Does he also look at sort of your life and what's been wrong, how you got there, and all of that sort of stuff?
What are the underlying reasons for you committing those offenses? Sometimes parents are going through a divorce and child is struggling emotionally and then they do something that they wouldn't usually do. It's not in their character, but it's a cry for help. So they, you know, like I say, I even had a child tell the mother, is this what I had to do for you to speak to me?
Oh, wow.
So, I mean, they go through extreme measures to get parents' attention.
Also, is that, you know, we put crime or criminal activity sort of in this box, and it's just something bad that naughty children do, or something that's naughty that children do, but really there's a whole sort of range of like other reasons that children resort to crime, and one of them is a cry for help.
Yes, or sometimes they just do something silly and we write it off as youthful indiscretion. You know, I stole something at the shop, I wanted the thrill of it. You know, but so the probation officer will then assess the child and make a recommendation. If the probation officer recommends child to be released, and she will obviously take parents' views into consideration, how they feel, do they want the child to be released or the child to be detained, then it's easy. The court just makes an order and out the child goes. But if things are formalized because the state is opposed and mother wants a child to be released, it can take a couple of days. Okay, so it's not a long,
it's not like a months-long sort of thing.
No, you cannot postpone children for more than 7 days at a time. Even bail proceedings, you cannot postpone it for more than 7 days at a time. And practically, we just try to, if we run out of court time, so we'll deal with the issue till about 4 o'clock. And if there's no more court time, we will roll it over till the next day. So we really try to expedite children's matters. And
Can I just ask you, sorry, because we just have 2 minutes left, but I just wanted to know also, just so if the child is incarcerated also, you were speaking about, diversion programs and they, preserving the rights of the child. And does that include, and so that parents know if that happens, so that's an option, they are allowed to visit their children also and they have access?
Yes. So the child and youth care centres, they do allow phone calls. They do allow visits on weekends. And they even allow kids to phone out to the parents on a Friday. So basically, I feel that there's a lot of times parents are involved in the rehabilitation and the reintegration process.
Which is great, which is necessary.
Yes, no, definitely.
So now we have 1 minute.
Okay.
I'm so sorry, but I just wanted to ask you within that 1 minute, as someone, you're a mother yourself, as someone who lives in the community, who works with these children, what is a quick message that you would give to parents out there?
Okay, so the message I would give to parents is, firstly, never give up on your children. No matter how bad things get, no matter what they've done, they are still children and we still need to support them. So I would ask them to stand by your kids, and sometimes taking them home is not best for them, but just still come to court and assist them, even though you cannot control them. Just be present in the child's life, because with effective rehabilitation, things can turn around, and courts can make orders, that a family time order that to basically reunite families, and things can get better. So don't ever give up on your children, and basically assist your kids wherever you can.
Yeah. Thank you so much. This has been such a great conversation, and I'm sure it's going to be useful to very many people out there. So thank you for joining us.
You're welcome. Thank you for having me. Just one last message. So if anybody needs free advice, you can always contact our toll-free advice line. So it's 0800 110 110. Or you can SMS, it's basically a please call me to 079 835 7179. And that's for free advice.
Fantastic. Thank you so much. We are going to take a short break, but we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and we've been speaking about children in conflict with the law. Now, we are almost at the end of our hour together, but before we go, we are going to have a look at a short video about how we can support our children and youth. Let's have a look.
Let's imagine a South Africa where everyone can live, play, and walk safely in their neighborhoods. A place where all people are and feel safe, and where communities can thrive. This is the vision of the Inclusive Violence and Crime Prevention Program, a joint South African-German development cooperation initiative. But this vision does not have to be just a dream. Making South Africa safe is possible. But where does violent behavior come from? Often it is a result of the environment people live in. Extreme inequality, overcrowded living conditions, inadequate access to good education, personal experiences of violence, and social attitudes that accept violence as a way of dealing with conflict are all examples of risk factors that can trigger violent or criminal behavior. The more risk factors someone is exposed to, the more likely he or she will become violent or become a victim of violence. Understanding these risk factors is the first step in preventing violence and crime. But just as there are risk factors that can trigger violence, there are also protective factors that help prevent violence from occurring in the first place. Such protective factors would be, for example, to provide a nurturing home environment with positive role models, to ensure young people have access to high-quality education and support for their personal development, to promote gender equality, and to create safe public spaces and provide recreational activities. The more protective factors that guard people throughout their lives, especially from a young age, the more resilient they become and less likely to be a victim of violence or to engage in violent behavior. To reduce risk factors and strengthen protective factors requires an integrated approach to violence and crime prevention that looks at the challenge holistically. Preventing violence and crime cannot be achieved by any single actor alone. The VCP program promotes such an integrated approach. It focuses on collaboration across different sectors and enhancing the skills of key role players to contribute to community safety. The South African government has adopted several integrated policies that promote violence prevention and help realize the goals of the National Development Plan and the International Agenda 2030. To support the effective implementation of these policies, the VCP program assists national, provincial, and local government to better understand and carry out their roles in preventing violence and crime. This helps to ensure, for example, that municipalities receive the information, training, and resources they need to make communities safer. Community safety is a collective responsibility. The VCP program supports various exchange platforms and networks to promote collaboration and knowledge exchange between all spheres of government and civil society. For example, the online knowledge portal Safer Spaces or the Urban Safety Reference Group, a peer learning forum that links South African cities. Citizens understand their communities best. Therefore, the VCP program explores innovative ways for them to be involved in making their communities safer. Many young people in South Africa have the strong desire to play a part in making a positive contribution to safety. The VCP program promotes interventions that empower the youth to become active citizens, training them to reach out to their communities, winning people over as change makers for safety, and becoming more resilient to risk factors in the process. Violence is preventable if we join in the efforts to address its root causes. Let's all play our part to make South Africa a safer place for everyone.
And that brings us to the end of the show. If we can remember the words by Thanaa Abrahams from Legal Aid, do not give up on your children. And while we know it might not be easy, the best thing you can do if they are going through this process is show up. Thank you for joining us. I'm Lenina Rasool. Goodbye.